How's it going? This is the topic analysis on the Jan-Feb topic. Resolved, plea bargaining ought to be abolished in the United States criminal justice system. So, notably with this topic, it's Jan-Feb, so it's the kind of longest topic of the year and the one that most rounds are on, which generally it's a topic a bit larger than this, but so you can expect that on a somewhat small topic like this, people who are trying to read new stuff for tournaments like the TOC later on in the topic will continue to kind of go to the margins of the topic and innovate in somewhat unexpected ways. But I'll try to cover what I think people will say early on in the year or in the topic and how I think some of that will develop. So, some general stuff on the topic. I think framework positions will be very big on this, just because a lot of the policy arguments seem to really decisively go neg. The main reason for that just being that plea bargaining itself has been around for a really long time. It's certainly like a very entrenched norm in our legal system, and that's like for a reason that it probably just from a truth perspective does help with efficiency in the courts, reduce things like court clog, etc. But the more important is just that very few people in the literature discuss abolishing it. Most people focus on limiting it to some extent, which would be a neg argument. So a lot of the good arguments for why kind of like abolition is key will come from more framework lens, which I won't explicitly cover in this. But those types of positions will have a better angle on like a principled reason why it's good for us to abolish it, as opposed to merely limiting it to some extent. Because in my opinion, the vast majority of strong policy arguments will focus on like in the literature, will probably conclude that a full abolition is not needed. But hopefully, we can find some that do, so that we can make good AF arguments. Um, Ks will also be a very big thing, just for the reason that it's a topic about the U.S. CJS. So people will certainly read like generic Ks like Afro-pessimism, CAP, etc. That generally are very relevant to that area. Um, Critical legal studies as well. But in terms of like topic-specific applications, people will make arguments about why plea bargaining is either doesn't do enough to fix the system or it's a non-reformist reform in that it is able to kind of go about making some changes to the system without being complicit in it as an AF argument. So there is definitely a lot of robust K literature um, and arguments about how plea bargaining affects like certain populations like the poor, women, minorities, etc. will all be important places to do research, but this particular TA will focus on policy arguments on both sides. So the core of the topic, it's probably not going to be if plea bargaining is good or bad, but just how much of it should be allowed. Just because I think that a lot of negs will read counterplans that maintain some degree of plea bargaining, but decrease it slightly as well in some cases. So I think it'll be a debate about the gradient of how much plea bargaining. Because I think that on a topic like this, it's unstrategic for the neg to kind of spot the AF that it's plea bargaining good bad, just because when there's such a big literature advantage to some plea bargaining versus no plea bargaining, and the negative can take a much more reasonable kind of halfway approach. Um, so I think it's likely that it's more likely you'll see a debate that's like abolish plea bargaining versus reform instead of is plea bargaining good or bad. So I think being ready for to have that debate round one of the first tournament will put you in a good spot. Either when you're neg beating an app that didn't do that preparation, or being ready to answer a counterplan that kind of agrees plea bargaining in the status quo is used in bad ways, but instead tries to change it. So in terms of the presumption of the topic, like how people think about it, as I mentioned in my previous TAs, I think this is important just because judges are human, they'll have opinions, and you'll want to kind of make arguments they find to be reasonable instead of making arguments they think are just ridiculous. And this is even like doubly true for rounds in front of like lay judges who will often make decisions based exclusively based on if they think you're being reasonable or not, as opposed to what they think you're winning on the flow or the line by line. So I think most people probably would intuitively dislike plea bargaining and think that it's bad and has been used in bad ways. And just like reading the news, you'll see stuff about why plea bargaining has been done in problematic ways. But in terms of abolishing it, that presumption then is heavily neg in terms of literature and I think people's opinions. Like I think if you ask an average everyday person what they think about plea bargaining, they would probably tell you that it's been used in bad ways. It's not great, but it's still important and shouldn't be completely gotten rid of, but just reformed in some ways. So the important thing then is that when you're asked to really emphasize how no plea bargaining is better than some plea bargaining and really play up that portion about why it's bad and used in bad ways. And the neg will certainly want to emphasize why there should be less of a dualistic approach, but instead viewing it more in terms of like gradients, like the ways it can be used in good ways and also the ways it can be used in bad ways. Um, the agent of action. So there's not explicitly an agent in the resolution, which I think is interesting. Um, but it does question in the United States criminal justice system, which to me makes it seem very likely that it's a question of court action, especially since plea bargaining is a legal kind of conception that's been established by courts and maintained by courts. So I think the AF very likely will defend some type of court action. But someone could also reasonably defend Congress passing a bill that then is like applied to the courts and changes the system. So I think it can go either way. I'd have to read more literature about that to really get a good sense of that. But I think certainly is an argument for either. And that means that like the NAG would get to read the other as an agent counterplan against the AF. And some disads that could be relevant for that. Possibly the prior questions doctrine, PQD, is a criticism of courts kind of both going back on their previous decisions, and like kind of taking a more active role in policymaking, which also could be a separation of powers. That's what we'll talk about more in the neg positions. But so the prior questions doctrine dissent would just say that they've courts have upheld plea bargaining for so long. Reversing on that would, excuse me, would be problematic just because it'd be a contradiction to what they've previously done. So that could make the agent very relevant, as will the separation of powers dissent, which I'll talk about. Um, in terms of the resolutional conflict, it seems to be individual versus the state, like such as should individuals be able to have lighter sentences or be forced to uh, not be able to negotiate down their sentences, like versus the state trying to figure out what's in the best interest of its citizens and just the criminal justice system altogether. Another could just be individual versus individual, because while criminal cases are individual versus the government, often they're on behalf of like a victim of a crime who is who and the government is trying to prosecute the case kind of to recognize. So I think so in the example of like someone who commits like intimate partner violence, it is very reasonable to assume that it's like plea bargaining would be an issue of the sentence for the perpetrator and the victim trying to get justice. So some definitions. Plea bargaining is just as most dictionaries have defined it, and it's just a system in which people in criminal cases can negotiate lower sentences in exchange for pleading guilty to something they may or may not have done. So, for example, if I killed 10 people, or yeah, that's kind of extreme. If I was robbing a bank and I fired my weapon and seriously injured the clerk at the bank. But there's not super great evidence that the gunshot came from my gun and not that of someone else who was robbing it with me. I might plead guilty to just like the felony of robbing someone and not plead guilty to and not plead guilty to the act of shooting the clerk. I would do that because I'd worry that if they found me guilty of shooting and seriously injuring the person, I'd have a much greater sentence. But if I plead guilty to a smaller offense, that both benefits the prosecutor because they can nail me on something instead of risking me walking through free altogether, or and it benefits me because I'm hedging my bets and making sure that I'm not found guilty of a much greater crime. So it's basically just a way for both prosecutors and defendants to kind of hedge their bets and accept a lesser sentence. So ought to be is interestingly enough in the passive voice. So it's the resolution isn't questioning a certain actor acting, but rather saying this just should be the case in the system, which I think is relevant in terms of like specifying the actor being having a resolutional basis for it. Abolished, I think, is probably the most important phrase, just because I think it determines whether or not Plan F's are T or not. So some people who define abolish in a much more wide-reaching, comprehensive sense would argue that plea bargaining, if it's abolished in the system, is abolished. There's just none of it. And plans aren't going to be a thing then, just because then there's no plea bargaining in the system. But others might say they defend abolishing a particular form of plea bargaining. So this will really just come down to kind of Nebel T type debates. And we should be ready on both sides of it. Like I think we should read plans just because the app's in a rough spot unless they're reading a framework position if they're defending the whole res. But I think we also should treat T abolished similar to T any or T any last year as kind of a core neg argument that we should really frontline and be set on. In the US, CJS is pretty straightforward. It's within the courts of the criminal justice system and not about civil cases or anything else, but just those particular types of cases. So some AF positions. I think specification is going to be strategic, even though we'll have to deal with the T abolish question. Just because I think the main type of prep that we want to orient the AF around is beating the court clog disad and beating the reform / curtail plea bargaining counterplan, just because I think those are the two most threatening neg positions. Court clog is very threatening because it's robustly supported in the literature, and the fact that the app is abolishing plea bargaining really magnifies that, I think, just because it's probably just a factually correct argument that plea bargaining helps with efficiency and helps reduce the amount of cases that have to be heard. So I think if the neg is able to do a competent enough job on uniqueness and the impact debate, they should win the debate on the court clog disad. However, defending a smaller AF obviously means there's less link uniqueness for the disad, because that would mean that let's say you only defended removing plea bargaining in intimate partner violence cases. That would mean that every other form of plea bargaining that already exists would kind of basically every other situation would mean that there would be more than enough link uniqueness for the disad to overwhelm any link. And what I mean by that is the plan would be kind of insufficient to trigger the link, and all of the other forms of plea bargaining that already exist would kind of make the system resilient enough. So even if getting rid of all plea bargaining would be bad, if it's only for a specific case, it wouldn't be enough to trigger the link to a disad like court clog. And so I think some types of things that people can specify would be, I think it might be on the next slide actually. Yeah, intimate partner violence. I saw an app that I don't like, but I think people might read about deportations, like plea bargaining for immigrants who might be deported, and deportation as a punishment. The reason for that, just that I think a counterplan that changes deportation policy would solve the entire app, like an advantage counterplan. Race apps like plea bargaining in some types of like drug-related cases that disproportionately harm minorities, or just like plea bargaining for black defendants, which I think runs into a lot of problems in terms of like who is black, how do we determine that, etc. But that's kind of a longer talk. Are all plans that people can read and that we can look into. And I think specific cases have a better angle on the on kind of answering to the reform / curtail plea bargaining counterplan. So that counterplan would just say, instead of abolishing it, we should just cut it back a little bit and reform the system, just because that it's more likely we'd have specific nuanced answers to that counterplan, like reasons why plea bargaining is always bad in those cases, or that the counterplan would have less of a good net benefit. Like I think the main one would probably be court clog, but I don't think that net benefit would be as good for the reasons I talked about why it wouldn't link to a super small position. In terms of straight up utilafs, I think crime is one, and one advantage area. We could talk about why plea bargaining increases the propensity for crime. It labels more people as criminal because people are more likely to plead guilty to a case, which could have impacts such as soft power. That if we look like we're full of crime, it's a very bad perception for us internationally. Soft power, it's also could just separately be have its own link, which is just that like tons of plea bargaining looks bad for us. That a lot other countries have totally different systems, and if our system is very different from those other systems, it's not a good look for us. Court legitimacy could also be one, either just like how Americans view the courts, or how they're viewed internationally, with a similar impact to soft power. Just that the when courts allow for things like plea bargaining, it looks like they're not rendering real justice. They're just deciding it on the basis of kind of expediency instead of actually trying to ascertain the right amount of guilt. And these arguments would probably be more just like with whole res Fs, but I suppose they could certainly apply in the context of a specific advantage area. So, like, if you establish some reason why court legitimacy on issues like IPV is especially relevant. Um, One thing I've thought about are impact turns to court clog. I'm not sure if I think this would be strategic just because impact turns on the 1AR are always tricky just because the 2NR gets 6 minutes to read new cards and they can just outcard the 2AR. But there could be some arguments. This would be better with a critical F, I think, that it's good for us to clog the courts and just completely shut it down because courts render just oppress minorities and cause like a litany of bad impacts. So kind of stopping the courts entirely is good. I think the risk with that, like I said, is just the time pressure. Plus, you'd have to kind of read a lot of impact defense to a litany of different scenarios, like court clog causing extinction, courts key to effective justice for minorities, etc. So I think that might be a little risky, but it could be something to explore with a more critical position. Um, so now some neg positions. This is, I think, much easier than figuring out AF positions, just because the neg has a lot of different angles to attack AFs. So I talked about this counterplan already, the reformed curtail plea bargaining counterplan. I think this is very strategic just because, from a truth perspective, there are going to be very few apps that have a good abolition key card and say why we should completely get rid of it instead of just changing it. Some people might go for theory against this counterplan, but I think that's very silly. Um, just because I think the neg shouldn't be punished for finding a good counterplan supported by the topic literature, but we should still make sure we have answers to that. Um, and like I said, a net benefit to this could be court clog. I think a pragmatism NC is also a very good net benefit to it, just because the pragmatism NC would probably just criticize the idea of abolishing and making a very kind of foundational judgment that plea bargaining is bad. Instead, we should like be open to revisions and be more kind of epistemically uncertain about it. So I think a reform counterplan would be good with that. In terms of different flavors of this argument, one of them could just be like kind of play out more like a pick, just limit it in these types of cases. Others would say we should like change some type of like sentencing guidelines, maybe change what prosecutors are able to look for. Um, Others could just be an advantage counterplan to kind of fix problems in the CGS more broadly. So I gave the example of like the deportations app. The negative could certainly make arguments about why we should just fix deportation policy, which would solve the entire app. Changing things like minimum sentencing laws might be able to stop things like the like drug convictions, and then a disad like court any topic disad, but something like court clog then is certainly a net benefit. Disads, court clog we talked about already. The important thing is to make it specific to criminal courts. So one mistake that I think a lot of people will make will be having cards that are about like patent protection and things like that. Those are different courts entirely than criminal courts. Those aren't like those were just tried in different areas. So making sure uniqueness, link, and impact cards are specific to criminal courts will be crucial. Otherwise, the disad might not even survive CX if the AF just points out why the plan only affects criminal courts. And having uniqueness that's good is obviously important. It should be recent, and if you're having difficulty finding reasons why courts are not clogged currently, some brink evidence could be good. Just that we are pretty clogged now, but we're barely like enough surviving enough for it to not totally collapse, and the AF collapses that, or even just making it a linear dised. Like, sure, it's not great, but it's operating fine. The plan makes it operate less. Although that's not usually super strategic for a variety of reasons, such as just that then it's easier for the AF to win a straight turn to it, and it certainly lessens the extent of the impact. K ground is also very good in terms of some of the stuff I mentioned at the beginning of the TA. So specific forms of like Afro-pessimism, CAP, CLS, etc. all both indict the use of the CJS and also indict kind of the the application of it to plea bargaining. But overall, I think the most successful MEG approaches will definitely be ones that don't just deal with plea bargaining being good or bad, but kind of the extent to which the AF gets rid of it, and kind of having several different layers in the 1MC, like a layer that agrees plea bargaining is good, or sorry, bad, but to the extent of it, but also just maybe a principled reason why plea bargaining is in fact good that kind of directly contests the normative ideals of the 1AC will be good, because then the 2NR has the ability to collapse to what's most strategic. But yeah, this topic seems interesting, even if the wording leaves something to be desired, and hopefully it'll go well. If there are any questions, just message me and we'll talk about the topic and hopefully develop some good positions.